Welcome everyone to this year's edition of Shareholder Proposals, Trends, Strategies, and Tactics for the 2018 Proxy season. My name is Hoang, and I am a partner in Dorsey's Capital Markets and Compliance Practice Group. I'm here with my colleagues, Gary Tygesson, who is also a partner in the group, and Associate Paula Kanne. So this year, what we'd like to do is give you an overview of 2017 proxy season trends and developments, share a few of our expectations for the 2018 proxy season, and then go a little bit more in-depth into responding to a shareholder proposal. We'll review some shareholder proposal basics based on Rule 14A8 of the Exchange Act and discuss the process for developing a response from a strategic standpoint. From there, we'll continue on to talk in depth about a process for including shareholder proposals, as well as the various bases and process for excluding shareholder proposals. So turning to 2017 proxy season trends and developments, overall, we saw fewer proposals submitted in 2017, 827, which was down significantly from the 916 that we saw in 2016, and the all-time high in 2015 of 943. There were shareholder proposals who on average received at least 30% of the votes cast in favor. And what I would note here is that these proposals are in different stages of their life cycles. There were some that have numbers and levels of support that have leveled off, including the independent chair proposals, golden parachutes, executive stock retention, supermajority vote, written consent, special meetings, and majority voting. And then there are proposals where we are seeing upward trends, including environmental and diversity proposals. But what about the behemoth of all sets of proposals, proxy access? Gary, where do you see that going?
Well, Cam, that really sprouted from a little seed a few years ago into the giant of our proxy season for the last 2 years. And while this past year it was still the single most commonly submitted proposal, there was a substantial decline in the proposals to adopt proxy access. And so we're seeing that on the decline now as more and more companies have moved ahead and actually adopted proxy access.
Good to know. Also this year, 25% of proposals submitted were withdrawn, which is consistent with prior years. And we also saw more no action relief granted by the SEC staff. The staff granted 78% of no action requests submitted during 2017, compared to 68% of requests granted during the 2016 season. And Paula will talk a little bit more about the bases for no action relief later on in this program. Focusing on the most commonly submitted proposals, as we look at this chart, we're seeing that many of the same proposals from last year were also front runners. And so proxy access, climate change, sustainability, lobbying and political contributions, independent chair and board diversity. The dramatic change that we have seen is last year there were 73 compensation proposals, the third most commonly submitted type of proposal. And those numbers have dropped dramatically with the exception of gender pay and equity. And so, Gary, I turn to you again. Do you have any speculation as to why this is the case?
Well, again, while there were 171 proposals to adopt proxy access last year and it led the way, it did decline significantly from the year before. And I think that's because many companies have already adopted proxy access and had done so before the 2017 proxy season. In addition, during the 2017 proxy season, a very large number of companies moved ahead and adopted proxy access, about 175 additional companies. And the list now includes over 60% of the S&P 500. This is all due primarily to shareholder engagement and shareholder proposals. We've also seen that the terms of proxy access bylaws have continued to converge, and the market practice continues to be what we call the 3-3-20-20 model, where holders of 3% of shares held for 3 years, aggregated by up to 20 shareholders, can nominate 20% of the board. Institutional investors are getting behind this model. For example, Fidelity now supports that market practice, except for smaller cap companies where it requires a 5% ownership threshold. So at the end of the day, only 28 resolutions came to a vote of the 171 proposals that had been lodged in. The support level was strong, actually higher than last year, and the pass rate was strong, also higher than last year. So while we expect to see some continued resolutions come before companies in this regard, you can also expect that if your shareholder proposal is in line with market standard, it's going to garner significant support and will most likely be adopted. Another trend this year, Cam, was the rise in proxy access Fixit proposals at companies that had already adopted a proxy access bylaw. In these Fixit proposals, shareholders can propose one or more amendments to existing bylaws. So you might see an amendment to change the aggregation limit, maybe from 20 up to 40 to 50, or maybe removing the limit altogether, or increasing proxy access nominees for the board from 20% to 25%, or removing renomination limits. There was a lot of concern at the outset of the proxy season about these proposals. A lot of companies were hopeful that by adopting a proxy access bylaw, Cam, they would have put these proposals behind them. And these Fixit proposals had a lot of people wondering if the cycle would just go on ad infinitum. But at the end of the day, many of the proposals were successfully excluded based on the substantial implementation standard, which we'll go into later. In addition, no proposal received a majority support, averaging 28% of the votes cast. So, is this a tempest in a teapot? Will we be seeing more of these proposals going forward? We'll talk about that in a minute. But also just wanted to mention that there was a decline in other governance proposals during the year. And this is perhaps probably the biggest sea change that we saw. Cam, if you lump all of the proposals that were submitted last year into larger buckets, and one of them is governance, and includes things like proxy access and independent chair, and other factors. And then if you put together another category of all environmental and social proposals that would include things like climate change and lobbying and political contributions and board diversity and other matters, you come out with the big picture that for the first time ever, all E&S proposals outnumbered all governance proposals, and it was by a pretty significant margin. So what's happened on the governance side of the ledger? As I mentioned, there was a decline in the other governance proposals this year from 493 to 409. And I think part of this is because a lot of companies, especially larger companies, have already implemented changes in response to prior shareholder proposals, shareholder engagement, or otherwise. We're continuing to see support last year, Cam, for proposals that covered topics like declassifying board terms, adopting majority voting in uncontested director elections, and eliminating supermajority provisions. We also saw a lot of proposals in the governance arena that did not get majority support. Items like independent chair, allowing a written consent of shareholders, and adopting special meeting rights. These proposals haven't gone away altogether, but they're not picking up any steam, and we expect them to sort of stay below the radar in terms of being adopted. So Paula, what happened on the environmental and social side of the ledger this year to catapult them into the lead?
Well, Gary, the 2017 proxy season will go down for sure as a turning point for key environmental and social initiatives. And that's as a result of pronounced shifts in the positions and voting policies of several major asset managers, with 3 resolutions on climate change winning majority votes for the first time at Occidental Petroleum, PPL, and the world's biggest oil producer, ExxonMobil. The proposals which deal with the business impact of the Paris Agreement, and for those of you not familiar with the Paris Agreement, that's an agreement that sets out a global action plan to put the world on track to avoid dangerous climate change by limiting global warming to well below 2 degrees Celsius. So those proposals saw average support surge to 45% from 38% last year. The most pronounced increase being a landmark vote at Exxon, where support rocketed to 62.1% from 38.1% in 2016, so big jump there. BlackRock, which had opposed to climate change resolutions in the past, designated it as one of its engagement priorities for 17-18. And media reports suggest that State Street, Vanguard Group, and Fidelity Investments supported the Paris Agreement proposals as well. As for board diversity, diversity activists continue to urge companies to improve the gender and racial mix of their boards. In fact, Cam and Gary, I don't know if you remember, the proxy season started with the statue of the fearless girl that was placed in front of the Wall Street Bowl. Became a huge tourist attraction in New York and obviously served as a symbol of investors' commitment to increasing gender diversity in the boardroom and C-suite.
Very true, Paula. And, you know, the definition of diversity continues to evolve, and so more and more boards are looking to see if they can add international members.
True.
And we are seeing some fundamental shifts in investor behavior on this topic. So State Street did vote against 400 nominating and governance committee chairs or senior members in 2017 because of their lack of movement on diversity.
Right. Of the record 33 resolutions filed, over 60% were withdrawn after the target firms agreed to increase the recruitment of women and minorities. Average support on those rose to 28% from 25% in 2016, and 2 proposals received majority approval, including at Hudson Pacific Properties, where support reached an all-time high of 85%. Also, interestingly, as Cam just mentioned, the 2 fund managers, again, BlackRock and State Street, promised to use their proxy voting power to drive greater gender diversity by voting against nominating non-diverse members. So, interesting approach there. In addition to board-level initiatives, efforts to promote workforce diversity accelerated this year as well, with double the number of proposals filed as in 2016. Largely sponsored by Trillium Asset Management at financial services firms, the resolutions request a breakdown of employees by race and gender across major EEOC-defined job categories and disclosure of the company's policies and programs for increasing diversity in the workplace. Half of the 2017 resolutions were ultimately withdrawn after the companies agreed to publicize their workforce diversity data. Support for the resolutions voted saw an increase averaging 29%, the strongest level since 2012. Moving on to gender pay. Gender pay equity has also emerged as a key focus, with approximately 19 proposals submitted in 2017 concerning the gender pay gap, compared to approximately 13 in 2016. These include 7 proposals submitted to financial institutions and credit card companies, requesting a report on whether the company, number 1, has a gender pay gap, number 2, the size of the gap, and thirdly, its policies and goals to reduce such gap. Around half were withdrawn as the companies reached agreements with the proponents, and on average, the 8 gender pay gap proposals that were voted on received support from 20% of the votes cast. This year's campaign, which includes financial services and consumer companies, as I just mentioned, reflects a similar shareholder proposal campaign which targeted last year, if you recall, technology companies. And that resulted in 6 leading tech giants agreeing to report on gender pay equity.
So Paula just told us about what was hot in 2017. I'm here to say a little bit about what was not, and that were the compensation proposals. So I had mentioned before approximately 70-odd compensation proposals in 2016. They were nearly eliminated in 2017, which continued a trend that began following mandatory say-on-pay votes. And we continue to see very strong support overall on say-on-pay proposals, with support levels averaging over 90% and very low failure rates since the mandatory vote was first introduced in 2011. We're seeing almost all of the S&P 500 companies, 95% of them, opting for annual votes. And in the realm of equity compensation plan proposals, shareholders are generally supporting those. Very few companies failing to get shareholder approval. Overall support levels averaging around 90%. The exception to this general trend is something that Paula discussed, which is the greater awareness around gender pay equity and potentially CEO worker pay disparity, especially as we begin to see 2018 pay ratio disclosure come into effect. So we may be seeing a reversal of that declining trend as attention is paid to pay ratio.
Thanks, Cam. So based on what we saw in 2017 and well as current conditions in the governance world, the question is, what can we reasonably expect for 2018 looking into our crystal ball? And we feel quite strongly that we're going to see investor focus continue to be increased in the areas of environmental and sustainability issues, cybersecurity, board diversity, and workplace diversity, and other issues of human capital. And we're expecting to see this in a number of areas. A continued uptick both in the terms of shareholder engagement with companies and ultimately shareholder proposals. And the reason that we're expecting this is because so many shareholders, particularly institutional investors, are now seeing these issues as a matter that are directly tied to long-term financial performance. We expect that proposals relating to governance, political and lobbying activities, and executive comp will continue to decline or experience similar levels as 2017 with similarly low success rates. The expectation for increased environmental sustainability proposals is driven by the recent and dramatic support by the key institutional investors. State Street, BlackRock, Vanguard, Fidelity, and UBS have all publicly announced changes in their voting policies that are going to result in greater support for climate change resolutions. BlackRock and State Street have announced that climate risk is a focus for company engagement. Fidelity has said that they're going to support shareholder proposals calling for reports on sustainability, renewable energy, and environmental impact issues. And UBS now votes for a large majority of proposals requesting that carbon dioxide emission reports, those that explain change risk to investors or explain what initiatives they're taking for the 2-degree global warming scenario. So this is, again, is a real sea change, Cam, and I think one that not a lot of us would have expected or predicted just 2 or 3 years ago.
Gary, as companies respond to these environmental proposals, what types of disclosure should they be focused on?
Well, that's a good question. I think a lot of companies are hearing this directly from their shareholders as they meet with their institutions and engage with shareholders, that shareholders want to see more in the disclosures with regard to what the company is doing on the environmental and sustainability front. Even for companies, for example, like insurance companies that don't have a carbon footprint except for whatever paper they use. So to the extent that you have felt in the past that the climate change rules really didn't apply to you for proxy statement disclosure or 34 Act reporting issues, that's still pretty much the case. The SEC does want you to talk about the effect of global warming and climate change on your business and include that discussion in your MD&A. But what we're talking about here is much more disclosure around what the company is doing in terms of its long-term sustainability goals. And you'll see, and we've seen, increased disclosure in proxy statements covering everything from the amount of paper a company uses to its carbon footprint to its ability to reduce greenhouse gas emissions, again, even for companies that are not in an energy-related business. And with regard to social issues, again, we're seeing demand from investors to talk more about what's going on in your proxy statement, even though there are no SEC rules that govern this area. So expect this to be kind of a company-by-company approach based on, one, what their shareholders are demanding, and two, what they're seeing their peer companies disclose on a voluntary basis.
Another area where we would expect to see increased activity in shareholder proposals is cybersecurity in light of the Equifax data breach, the data breach at the SEC, and numerous other examples over the past year. And so we would expect to see proposals requesting reports on how boards are overseeing privacy and data security. And we do believe this trend will be reinforced by signaling from the SEC recently. So to quote SEC Chair Jay Clayton at a recent NYU conference, "I am not comfortable that the American investing public understands the substantial risk that we face systemically from cyber issues, and I would like to see better disclosure around that. So perhaps it's time to dust off the SEC staff guidance on cybersecurity, which discusses, among other things, considerations relevant to a company's risk factors, MD&A, description of business, discussion of legal proceedings, financial statements, and disclosure controls and procedures. Because it goes without saying that those companies that are attentive towards their disclosure outside of this purely shareholder proposal context will be best able to bolster their argument that they are prepared for a cybersecurity breach. And some key messages that we believe companies should consider would be around a company's preparations, not only for if an attack happens, but when the attack happens. So are there plans in place for disaster recovery and response, and how can those plans be described? And boards and companies will also want to take a systemic view of cybersecurity versus treating them as isolated incidents. So to the extent that a company's disclosure can communicate this view and communicate this approach, it can be very helpful and potentially reassuring to investors that the company is indeed coordinating across functions and not seeing this as an issue within separate silos, which unfortunately can get you into trouble.
Moving on to board diversity. I don't know how many of you are familiar with the New York City Controller Boardroom Accountability Project, so I'll just give you a little background. After launching a trailblazing boardroom accountability project in 2014, which was done to give investors a real voice in who sits on corporate boards, on September 8th of this year, the New York City Controller and the New York City Pension Funds launched the Boardroom Accountability Project 2.0, calling now for 151 U.S. companies to disclose, number one, race and gender of their directors, along with two, board members' skills, and third, demographic background. All of that in a standardized matrix format. The hope of the project is that disclosure will increase transparency and accountability across the market and push more boards to be diverse. Well, companies are now recognizing the importance of board diversity as material to investors, and more than 45% of Equilar 500, and for those of you not familiar with Equilar, it's a sample of the largest public companies as measured by revenue. So 45% of those companies disclose their board composition as it relates to gender diversity, and nearly 40% included information about their directors with respect to racial or ethnic background. In addition, companies are also voluntarily providing detailed information about their directors' skills to help investors and other stakeholders understand how they're approaching board composition. For example, in the Equilar 500, 18.4% of the companies included a board skill matrix in their proxy statement. So we expect lots of progress in here.
For 2018, we also expect to see a decline in proxy access proposals, down from this year and prior years, in part because so many companies have adopted them. Proposals to adopt proxy access bylaws we expect will trickle down to mid and smaller cap companies, depending on how much energy and resources shareholder proponents want to put into this effort moving forward. At this point, over 60% of the S&P 500 have already adopted proxy access bylaws. It doesn't mean you're out of the woods yet if you haven't adopted a bylaw, and you should consider whether or not you want to do that and whether you want to get out ahead of a potential shareholder proposal. We would expect proposals to amend proxy access bylaw provisions to continue, the so-called Fixit proposals. Although they weren't very successful this past year, it continues to be an area that shareholder proponents are fixated on. I think your company is more at risk here, Cam and Paula, if you have a company that has a bylaw in place that's out of the mainstream 3-3-20-20 model. For example, if your company has a 5% shareholder ownership threshold, you can expect to be a target for a shareholder proposal. We expect that there's going to be a basis for exclusion for many of these proposals, depend on the substantial implementation basis. That is definitely a possibility. We'll talk about this more later, but the SEC has been somewhat vague, less than clear on how it's going to apply this standard in the context of proxy access proposals. So we're going to continue to monitor that going forward and watch what happens in the no action letters in terms of grounds for excluding these new proposals and variations. You should also just be keeping an eye on the big picture here in terms of the legal framework for shareholder proposals, in terms of what might be changing there. There are a number of potentially significant proposals under consideration, but they're not likely to be adopted in time to affect the 2018 proxy season. You should be aware, however, that the Financial Choice Act 2.0, which was adopted by the House earlier this year, would increase share ownership thresholds for submitting shareholder proposals, as well as increasing resubmission proposals and prohibiting proposals by a proxy other than a shareholder. It's really hard to say if and when Financial Choice Act 2.0 will be taken up or adopted by the Senate, and what provisions would ultimately be adopted, if any. But the Trump administration is clearly on board with curtailing the shareholder proposal mechanism, and as noted in the very recent report from the Treasury Department, Treasury Department has also come on board recommending substantial revision to the share ownership threshold and resubmission thresholds. Also to note is that SEC Chairman Clayton has indicated that he's open to thinking and rethinking the parameters around shareholder proposals. I have to say, though, Cam, that there's very strong voices on the other side of this, and it'll be interesting to see if any movement is made at all. Also just want to note for you that the universal proxy card has been put on the back burner. The SEC's proposed rules for adopting this have now been moved to a long-term goal under Chairman Clayton. If the Financial Choice Act is adopted as drafted and is adopted by the House, that would prohibit the SEC from mandating universal proxy. So in a contested election for directors where you have competing shareholders and competing proxy statements and proxy cards, you wouldn't be faced with having a universal proxy dealing with shareholder proposals. I think the big question for us all is to what's going to happen with investors and activists as they react to and respond to Trump administration initiatives to pare back regulation. At this point, quite frankly, we've seen a resurgence in shareholder and investor interest in these topics and wanting to hold companies' feet to the fire even if provisions of Dodd-Frank are repealed. And we've also seen a resurgence in investor activity around environmental and social issues. So to us, that's kind of the big picture going forward, and whether or not we're going to see anything come out of the reaction of the Trump administration in time for 2018 is kind of up in the air. Since not a lot of these initiatives have been adopted yet, Cam, though, it's hard to say whether or not particular shareholder proposals could even be drafted around the proposed initiatives.
The annual ISS Governance Principles Survey results are always worth a look because they may sometimes suggest where ISS is more open to recommending votes for shareholder proposals. And so the topics that we saw highlighted this year included multi-class share voting structures is really kind of a fascinating policy discussion here. You know, should markets or regulators decide whether or not companies like Facebook, Alphabet, Google, Workday, LinkedIn, whether they can adopt multi-class share voting structures. And so in the ISS survey, only 5% of investors said that companies should be allowed to choose whatever structure they see fit, but are they willing to vote with their investments? According to an April 2017 report from State Street Global, if the S&P's recently effected ban on including multi-class share structure companies in its indices had been in place over the past decade, S&P 500 index returns would have fallen from 86.5% to 84.6% over that last decade. Elsewhere in the ISS survey, over 2/3 of investors said that 0 female directors on a public company board is problematic, which is consistent with what Paula had reported to us earlier on in this webinar. A plurality of investors, 44%, said that both share issuances and buybacks are matters to be voted on by shareholders. Similarly, a plurality, 36% of investors, indicated that hybrid shareholder meetings are acceptable, but virtual-only meetings are a no-no. One of the most interesting results I found from this survey this year was that 75% of investors intend to either compare pay ratios across companies or assess year-over-year changes at an individual company, or do both. So this level of scrutiny is something that may be unexpected for a lot of companies who are just really hoping that the CEO pay ratio will be an issue that stays under the radar. So that concludes our prognostications on the trends for the 2018 proxy season.
Well, back to the basics. As you know, shareholder proposals are matters that shareholders of public companies seek to have acted on annual or any other meeting of the company. Mostly based on requirements of state corporation laws and company organizational documents. A shareholder may seek to have a matter voted on by raising the matter at a meeting of shareholders. But alternatively, a shareholder may seek to include the proposal in the company's proxy statement under Rule 14A of the Exchange Act. For those of you who haven't had a chance to take a look at this rule, it's very easy to read. It's in a Q&A format. Virtually all shareholder resolutions are non-binding, or as we like to call them, precatory, to use the legal term of art. That's because the company's board can make its own determination as to whether adoption of all or any part, for that matter, of a shareholder proposal is in the company's best interest, even if it received majority support from shareholders. For this reason, we've seen a lot of investors now shifting their focus to bylaw amendments to implement corporate governance reform as opposed to the traditional non-binding shareholder proposals, since they're merely recommendations for board action. So who's eligible to submit a proposal? To submit a proposal, a shareholder must have continuously owned at least $2,000 in market value or 1% of securities entitled to vote for at least 1 year. If the shareholder is not a registered holder, and by that we mean his or her name doesn't appear in the company records as a shareholder, then the shareholder must prove eligibility. And there are a couple choices here. First, shareholder can submit to the company a written statement from the record holder, usually a broker or a bank that's a DTC participant. Or the shareholder may submit a copy of the Schedule 13D or 13G, a Form 3, 4, and or 5. Obviously, the shareholder must continue to hold the securities through the date of the meeting. As you can imagine, the power of those fairly small investors to submit proposals has been subject of controversy and calls for reform. As Gary just mentioned, the Financial Choice Act of 2017 has been approved by the U.S. House, and that would change the threshold to vote to at least 1% of the outstanding stock held for 3 years as opposed to 1 year. Now, the bill's destiny will be in the hands of the Senate, so we'll watch for that.
Paula, so who are the most prolific proponents that you're seeing of shareholder proposals?
Great question, Kim. Shareholder proposals come from a variety of shareholders, sometimes referred to as proponents. Shareholder proponents may be individual investors who are seeking to raise a particular issue or implement a policy at a company. It could be public pension funds or entities who this last season proposed more than 140 proposals. Could be labor unions, activist investors who are seeking to bring about a change in control or a change in the strategy or policies of the company. Or institutional investors who may be focused on particular corporate governance or social issues. Another question covering the basics here would be, when should a proposal be submitted? Well, a shareholder must submit the proposal at least 120 days before the date of the company's proxy statement for the previous year's annual meeting. If by chance the company didn't have an annual meeting during the previous year, than a reasonable time before the company begins to print and mail its proxy materials. Under guidance provided by staff, Legal Bulletin 14F, and by staff here we mean the staff of the SEC's Division of Corporate Finance, under this guidance, if a shareholder proponent submits a revised proposal before the company's deadline, then the company must accept the revised proposal. But if the shareholder submits it after the company's deadline, then the company doesn't have to accept the revised proposal. As you may be aware, the proposal, including any supporting statements, may not exceed 500 words. The staff has, though, indicated that it counts a website address as one word for purposes of this limit. And that's because the staff has said that that's because it doesn't believe that a website address raises the concern that the rule was intended to address. As for graphics, that's still case-by-case analysis, but generally they don't count towards the 500-word limit.
In the materials that were sent out before this webinar, we included a table of key deadlines for responding to shareholder proposals that we hope may be a good resource for you in your work. It goes without saying that one of the most common bases for excluding a shareholder proposal is challenging the proponent's eligibility and procedural compliance with proxy rules. So in addition to the ownership and timeliness requirements that Paula has discussed previously, some other restrictions to bear in mind. Each shareholder may only submit one proposal for a particular shareholders meeting. The proposal, including the supporting statement, may not exceed 500 words. The company must notify the proponent of any deficiencies and a time frame for response within 14 days of receipt of the proposal. And subsequently, if the proponent fails to respond within 14 days of receiving the company's notice, then the company may submit a no-action letter requesting the right to exclude the proposal. Notice does not have to be given for deficiencies that can't be remedied, such as a failure to meet the proposal deadline.
It's amazing, actually, how many proponents fail to meet these technical requirements, and we've actually had a lot of success excluding shareholder proposals because they didn't meet these simple requirements and they didn't respond to the company's notice of deficiency. So check these out.
For sure. Thanks, Gary. Now we're going to move on to a discussion about thinking about the goals for shareholder engagement and thinking about the goals in responding to a shareholder proposal. And here we see a whole spectrum of objectives that a company may have when it's faced with a proposal. For some companies, they see shareholder proposals as an opportunity to advance the company's position on the issue, strengthen the relationship and reputation with shareholders, collaborate with shareholders on further study of the proposal. There are companies, and depending on the issue, who look at shareholder proposals with a more defensive mindset. And so they're seeking to discourage future proposals and minimize disruption to board and management processes in terms of the time and resources that are spent on shareholder proposals. As we see that many of these environmental and social proposals are no longer being backed just by the smaller investors, but institutional investors with economic weight and long-term holdings are weighing in, I would expect, number one, that there will be more companies who are gravitating towards the first part of the spectrum, where they are in open engagement mode. And number two, I would expect to see more negotiated settlements of proposals. Now, companies may have a general philosophy about how they address shareholder proposals, but it's increasingly a good idea to have a more nuanced approach and to think through goals for shareholder engagement by topic. So, for any particular company, what are the issues that pose the most risk for that company's business? Is it supply chain, human capital, sustainability? Furthermore, what's the time horizon for the risk? To make a thoughtful assessment of each shareholder proposal and to make the appropriate shareholder engagement investment, these are some of the questions that should be considered. Other factors to consider include alignment of proposal with current and future company policies, treatment of similar proposals at peer companies, investor and other stakeholder positions, the company's relationship with proponents, and the likelihood of future proposals. And so we've included in here just an example of a shareholder proposal response plan, a decision tree that can guide your company through the decision-making process and the process of articulating your goals for the shareholder proposal. And it's here just as a reminder that companies should have a systemic approach to these proposals year over year versus having just an ad hoc approach to these proposals.
And I think, Cam, one of the biggest areas where in-house counsel can add value and where we can assist in-house counsel is helping companies work through this decision tree and the various factors to consider. I mean, ultimately, whether or not to include the proposal in the proxy statement will be decided by the board of directors and will be based on management's decision, being advised by counsel. So this is an area where a lot of an analytical thought is brought into play, and if you were to decide for whatever reason to go ahead and include the shareholder proposal, perhaps you've determined that there really is no reasonable basis for excluding it, or perhaps you've decided that it's the right thing to do for the strategic or relational issues to include it rather than seeking to exclude it. There is a short list of technical requirements that you need to be aware of and you need to follow. If you're going to oppose the proposal, the company has to send a copy of its opposition statement that it plans to print in the proxy statement to the shareholder proponent 30 days before it files the definitive proxy statement. And the proponent has the ability to challenge any false or misleading statements in that statement in opposition. The proxy statement has to include some details about the shareholder's name and address and the number of shares they own, or the company can state in the proxy statement that it will provide the information to shareholders upon request. It's also important to note that if the proponent or a qualified rep fails to show up at the annual meeting to present the proposal without good cause, the company is allowed to exclude all of the proponent's subsequent proposals in the next 2 calendar years. The more difficult path, if you head down the path to seek to exclude the shareholder proposal, is the more difficult path, and that's what we're going to kind of cover here and focus on for the remainder of our time today. Again, there are some very technical requirements and firm deadlines that have to be met if you're going to go down the exclusion path, so be mindful of those. To exclude a proposal, that requires you putting together a no-action letter request and submitting it to the SEC. It has to be submitted at least 80 days before your mailing date for the proxy statement. So that doesn't give you a lot of time after receiving the shareholder proposal to go through your analysis, your decision tree, your timeline, and determine whether or not you're going to exclude the proposal. After you've submitted your proposal, the proponent also has the opportunity to weigh in, and the SEC will weigh all of the arguments and decide, typically within 30 to 60 days. This year, the SEC was very proud of their quick turnaround time. They staff up during proxy season and try to get back to you actually before the 30 days elapses, but you do need to build in more time just in case they're slow. The staff has also provided some additional guidance informally that we just wanted to make you aware of. The staff has requested that they really like to be kept apprised of any major developments in your discussions or negotiations with the proponent following a no-action letter request. So if you decided with your proponent to not oppose it or to negotiate something in order that the proponent will withdraw the proposal, be sure to let the staff know as soon as possible. If you are providing deficiency notice to the staff, you can eliminate providing all the extra copies of Rule 14A8 and the staff legal bulletins. If you do include the proposal in the proxy, you have to be mindful of the CNDIs on this and the staff statements that you must provide a good description of the shareholder proposal in the proxy card. You can't just simply say shareholder proposal with a checkbox. Finally, they've said repeatedly, informally, don't call them repeatedly looking for a response. It's a busy time for them. They'll get back to you as soon as they can. An occasional call is okay, but don't bug them.
Aside from eligibility and procedural requirements, a company may exclude a shareholder proposal from its proxy materials if the proposal falls into 13 specific substantive bases for exclusion. And those represent areas where the SEC has determined over the years not to be appropriate matters for consideration by shareholders through this process. Some common examples are, number one, if the company has already substantially implemented the proposal, which makes sense. Number two, if the proposal deals with a matter relating to the company's ordinary business operations. And number three, if the proposal or supporting statement is contrary to any of the Commission's proxy rules, including the prohibition on materially false or misleading statements in proxy soliciting materials. In this next slide, we've listed for your reference here the other 10 grounds for exclusion, which I will not bore to read to you, but you have it there for your reference.
So looking back at a very commonly cited basis for exclusion, the ordinary business basis, there are two frequently cited considerations for evaluating whether an activity is within the ken of ordinary business. One, whether the tasks are so fundamental to management's ability to run a company on a day-to-day basis that they could not, as a practical matter, be subject to direct shareholder oversight. And the second consideration is whether the proposals seek to micromanage the company by probing too deeply into matters of a complex nature upon which shareholders as a group would not be in a position to make an informed judgment. So when would a shareholder proposal be excluded because it micromanages a business? As we see from a series of no action letters from 2017 on proxy solicitation and proxy voting, the line can be fine indeed. In January of 2017, the staff granted no action relief that would allow companies to exclude shareholder proposals, preventing management or the board from accessing preliminary voting results on uncontested matters prior to the annual meeting, including a running tally of votes for and against, and using that information to solicit votes. And in this series of no action letters, the staff had concluded that the proposals relate to the monitoring of preliminary voting results with respect to matters that may relate to the company's ordinary business. But in that clause at the very end, the qualifying clause, with respect to matters that may relate to the company's ordinary business, the staff left open the possibility that there are certain situations where there are proposals on management access to preliminary voting results that may in fact not relate to ordinary business. And so subsequently, in March of 2017, the staff refused to grant no action relief on a proposal that was limited to management and the board's access and use of the outcome of votes cast by proxy on certain executive pay matters. And so where is this line, you may ask? It's one that does shift from time to time, and often there can be a significant policy issue that raises an exception. And so what constitutes a significant policy issue? In the staff's June 2016 stakeholder meeting, they defined it as a matter of widespread public debate that includes legislative and executive attention and press attention. And so where a shareholder proposal addresses a significant policy issue, then the ordinary business basis for exclusion is nullified. Some recent and popular significant policy issues include environmental and social proposals, including political spending, sustainability reporting, and diversity and non-discrimination proposals. So just one example of a proposal that cannot be excluded under this rubric: a proposal requesting a report detailing the known and potential risks and costs to the company caused by any enacted or proposed state policies supporting discrimination against LGBT people. An example of a social responsibility proposal that can be excluded is one that was presented to Apple and Deere & Company in 2016. It was a proposal requesting that companies generate a plan to reach a net zero GHG emission status by the year 2030. And the staff there concluded that there was micromanagement. And so what's the distinction here? It may very well be that the plan specified certain targets and just stepped over a boundary where the staff said, okay, this is no longer just a significant policy issue. This is unacceptable micromanagement. To further complicate the issue, as we saw in Trinity Wall Street versus Walmart stores in 2015, courts and the SEC may disagree about what constitutes a significant policy issue. In that case, the Third Circuit presented a two-part test as to whether the significant policy exception applied. Number one, does the proposal transcend the day-to-day business matters of the company? And then, number two, does it raise policy issues so significant that would be appropriate for a shareholder vote? The SEC staff subsequently confirmed that it will continue with its one-step approach, whereby significant social policy issues, by definition, transcend ordinary business and therefore are not excludable. So while it is rare and costly for shareholders to go to courts to overturn a no-action decision, it does happen. Courts tend to be less deferential to staff decisions versus a ruling by the commissioners. But ultimately, the staff may decide how broadly to apply the ruling from the court to future no-action requests, and it does have considerable latitude to interpret SEC rules.
Cam, this just seems like a real morass here in terms of trying to advise a company or to advise your client internally whether or not you're faced with something that would be a significant policy issue. In terms of the types of proposals that we've been seeing this year, it seems like this kind of vague approach at least gives us an opportunity to make the argument that it can be excluded. What are your thoughts on that?
Well, I do think that with the environmental and sustainability issues and many of the diversity issues, that it would be a challenging argument to make, but it really lies in the existing fact pattern. And so some things to consider is how specific is the proposal? Are there certain targets that are being proposed? Is the proponent making a proposal about what type of product business is allowed to sell? Those are some of the more successful bases for exclusion that we've seen in the past.
Good thoughts, thank you. Another prong for excluding a shareholder proposal is Rule 14A8I9, which allows a company to exclude a shareholder proposal if the proposal directly conflicts with one of the company's own proposals to be submitted to shareholders at the same meeting, the so-called conflicting proposals basis. Previously, there was a lot of ambiguity about how the staff was going to apply this exception, and then the staff took it under review and actually suspended issuing no action letters under this basis in 2015, an almost unprecedented move, and this was in the face of a lot of conflicting proposals around proxy access and the famous Whole Foods no action letter. So the staff took this under advisement and came out with an approach under SLAB 14H in October of 2015. And their approach really focuses on whether there is a, quote, direct conflict between management and the shareholder proposals. And they say that a direct conflict would exist if a reasonable shareholder could not logically vote in favor of both proposals. In other words, a vote for one proposal is tantamount to a vote against the other proposal. So how does this apply to actual proposals? Examples of direct conflicts that could be excluded on this basis would be, for example, if a company is seeking shareholder approval of a merger and a shareholder proposal asks the shareholder to vote against the merger. Obviously, it's either for or against. You can't vote for both. Also, if a shareholder proposal asks for the separation of the company's chair and CEO, and management proposes that the provision in the bylaws require the CEO to be the chair at all times, that may be excluded because you can't vote for both. It's one or the other. In the Illumina no action letter, we saw that a shareholder proposal that provided for greater than simple majority voting standards be eliminated could be excluded, where management proposal sought that existing supermajority voting standards be approved. So again, it's either yes or no on supermajority voting standards. Where you run into difficulties, however, is where a shareholder could conceivably vote for both proposals. So, for example, a shareholder proposal that would permit a shareholder or group of shareholders holding at least 3% of the company's outstanding stock for 3 years to nominate up to 20% of directors cannot be excluded if management throws in an alternative with 5% of stock held for 5 years to vote for 10% of the directors. Arguably, a shareholder could vote for either or both of those, and the company would have to decide which way to go. Similarly, on a compensation issue, we saw that a shareholder proposal asking for the Compensation Committee to implement a policy that equity awards would have no less than a 4-year vesting requirement could not be excluded when management lobbed in a proposal that provided the Compensation Committee the discretion to set any vesting schedule whatsoever. The substantial implementation basis has been a fertile ground for trying to exclude in the past proxy access. And 14A8I10, substantial implementation, permits a company to exclude shareholder proposals from its proxy materials if the company has substantially implemented the proposal. This rule was designed to help to avoid the possibility that shareholders have to consider matters which have already been favorably acted on by management. So applying this in the context of substantial implementation and proxy access, we had a series of no-action letters early in 2016 that allowed companies to exclude proxy access proposals if they had adopted proxy access bylaws that fulfilled the essential objective of the shareholder proposal. It was totally left undefined what essential objective meant, and that's the subject around which you would frame your no-action letter if you're seeking to exclude the proposal based on substantial implementation. We did see in 2017 that a number of the proxy access Fixit proposals were allowed to be excluded on the substantial implementation prong. Here it sort of broke down into whether or not the proposals were one change to the bylaw or for multiple changes to the bylaw. If the proponent sought to adopt a number of changes to the bylaw, those were more easily excludable if the company agreed to adopt a portion of the proposed changes. For example, if the company had previously had a 5% ownership threshold and they agreed to reduce it to 3%. The staff was inclined to exclude those proposals where the company had made those changes and were able to determine somehow by looking at the entire proposal and the company's bylaw that the essential objective of the shareholder proposal had been satisfied. I think what we really saw here was a winnowing down of what the staff saw as the most important issues, and that being the 5% or 3% threshold. Where the proposal was for just one revision, here companies were able to get no action relief where they were able to provide specific data on both the size and duration of holdings of their shareholder base. And they use this information to try to demonstrate that when applied to the particular proposal, it wouldn't really make a difference as to whether or not shareholders would have an adequate proxy access remedy. For example, if you sought to change the ownership threshold or increase the number of shareholder proponents that could be included in aggregating to reach that threshold, if you could show by your shareholder records that you have an adequate number of shareholders currently holding shares such that meeting a lower threshold is not a problem or having a lower aggregation threshold is not a problem, you are likely to be able to have that shareholder proposal excluded. This is not entirely clear, and as I said earlier, this is an area that we're going to be looking at no action letters during the coming season to see where the staff comes out. It'd be interesting to see on all these bases, Cam, whether or not the SEC under the Trump administration and under Chairman Clayton takes a different philosophical approach on any of these bases for exclusion. We expect to see continued proxy access and proxy access Fixit proposals, and we expect to see many companies try to exclude them on the substantial implementation grounds. So we see this as a fertile area for further no-action letter development this year, and it's going to be interesting to see whether or not the Trump administration has any, and the Clayton administration of the SEC has any impact on how the SEC decides these no-action letter requests.
Well, that concludes our prepared remarks for today. Before we leave, Gary and Paula, do you have any final remarks about the 2018 proxy season that you'd like to share with us?
Not me.
I'd just like to say that again, I think we're all facing a lot more activity from shareholders in terms of engagement in shareholder proposals on the environmental and social front. That's certainly been the buzz at corporate governance sessions, and corporate governance professionals are of a similar mind, and so stay tuned for that. Governance proposals are certainly going to continue to be made and will in many cases continue to be adopted based on the type of proposal, but I think we're seeing a whole new avenue opening up, and it's one that's garnered quite a bit of shareholder support, so it's no longer something that just has to be included in the proxy statement or sought to be excluded without any concern as to how that's going to affect your long-term shareholder relations.
Thank you very much for joining us. Have a good afternoon.